Letter to the Right Honourable Beverley Hughes MP, 18th of August 2005. Dear Beverley, you may have seen in the newspapers that I am involved with a very distressing case in which a constituent's family have had their children removed by Essex County Council and have now been put up for adoption. I will not go into the details of the case, but it does raise some concerns I have about the way in which the Children's Act is working against people with special learning difficulties, and how the secrecy that surrounds the family court is an obstacle to justice. The mother of the children has an IQ of around 60, and while social services sought to present her as stupid to the point of being unable to understand maternal feelings, she is, in my view, just a little slow, and loves her children dearly. Faced with an unending stream of social workers, I counted up to 16, pushing her in different directions, she was left bewildered and unable to adequately cope with putting up a rebuttal for social services allegations. It was very noticeable in the judgment that while the judge took into consideration her learning difficulties in assessing my constituent's adequacy as a mother, the same judge ascribed quite sophisticated motivation with her use of the press and my involvement in the case. I feel very strongly that had my constituents been able to seek advice and support from outside organisations or their elected representative from the beginning, they would not now be bereft of their children. From day one, both my constituents needed people around them that understood the needs of people with special learning difficulties. Given that I understand that 20% of care proceedings now involve parents where one or more have special learning difficulties, I am fearful for the vulnerability of these parents in what appears to be an unequal battle with social services. Because of the secrecy that surrounds family court proceedings, I am not aware of the plight of my constituents until after the initial adoption hearing. As you are aware, the law changed in April to allow MPs access to case material and to discuss matters with social services on behalf of their constituents. It may well be that I was among the first MPs to take advantage of the change in the law. And while the social workers were courteous and professional throughout, it was clear to me that they resented both my questioning and my involvement in the case. Indeed, they refused to meet me for a second interview, saying that it was now in the hands of the court and there was nothing more that they wished to say. Thanks to the intervention of the Leader of the Council and the Chief Executive, I obtained a second and lengthy interview. I do not believe that the secrecy surrounding the family court is healthy. I think it breeds an atmosphere where professionals speak to professionals in language which is confusing to the layperson and at times incomprehensible to the parents. There is an inconsistency in the way in which the law operates between proceedings in the family court and criminal proceedings. In criminal proceedings, as you know, the parents were permitted to discuss any issues and allegations subject to the identity of the children remaining secret. Parents in the position in which my constituents find themselves should be able to seek advice, counselling and help, not just from professionals, but from others who have a bearing in their lives. I will now give two examples. As the law stands, my constituents, without the leave of a court, could not inform his employers of his plight. In such circumstance, an employer clearly needs to know why someone is absent from work so often or receiving personal calls. A caring employer would, I am sure, want to offer moral support to their employee. It is common in these cases for parents whose children are in care to be referred for psychiatric assessment, and again the leave of the court is required before full disclosure is made of the parenting circumstances. I note the Select Committee is considering the effect of the Children's Act and recommends more transparency, and I would like to add my voice to this recommendation. I will, of course, when Parliament resumes, seek an opportunity to raise this matter on the floor of the House, and would welcome an opportunity to discuss problems of parents with special learning difficulties with you direct. Because of their interest, I am sending a copy of this to Theresa May MP and to Alan Beath MP. Yours sincerely, Errol Pickles MP of Brentford.